Good morning, student. Welcome to the PGDBL program, that is Postgraduate Diploma in Business Law. I am Dr. Janami, Department of Studies in Law. I am Assistant Professor. Here consists of 6 papers or 6 courses, out of which first course is Public Law. Public Law having 4 blocks. In first block we are dealing, that is the salient features of Indian Constitution. As we all studied the Indian Constitution at degree level, we know that what is Indian Constitution when it came into force. We are all know that Indian Constitution, the framers of Indian Constitution, after the in-depth study of manifold challenges, problems including poverty, literacy, illiteracy, deprivation, inequality, the Indian Constitution came into force. Indian Constitution of any country is the supreme law of the land. It lays down the structure of the government, and it defines the powers, responsibilities and functions of the each organ of the government. Therefore, it is considered to be the basis of the governance of the country. For governing of the any country, the constitution is very much essential because it laid down the structure of the state and power, functions and responsibilities of the states. And also in addition to that, it explained the rights and duties of the citizens. Since the constitution is the supreme, all laws enacted by the state legislature should be conformity with the constitution. The constitution, to frame this constitution, around it took 3 years, means 2 years, 11 months, 18 days. All we know that is Dr. Ambedkar is the chairman of drafting committee chairman. Because of all members of the drafting committee effort, we got the Indian Constitution. It was submitted on 26th November 1949. It was came into force in 26th January 1950. So now we have studied the salient features of Indian Constitution. Totally the 13th salient features are there. First one is the longest written constitution, second one is preamble, third one is fundamental rights, fourth one is directive principles of the state policy, then fundamental duties, parliamentary form of government. The seventh one is federation with a strong centralized tendency. Next one is a unique blend of rigidity and flexibility, judicial review, universal adult suffrage, single citizenship, independent judiciary and secularism. We have to discuss one by one the essential features of Indian Constitution. First one is the lengthiest written constitution. As we know that Indian Constitution is the, compared to in the world, Indian Constitution is the lengthiest constitution. In USA Constitution having only the 7 articles. But at the time of making the constitution, framing of our constitution, it consists of 395 articles. It is scattered in 22 parts and 8 schedules. But now at present, because of various amendment, because of a number of amendment, now you are having a 448 articles divided in 25 parts, and we are having at present 12 schedules. Why this constitution is so bulky? Because of the following reason. First one is, we follow the British parliamentary system of the government, that is bicameral legislature. It embodies the fundamental rights which are similar to the Bill of Rights we have seen in United States of America. It elaborates the directive principles of the state policy as does in Irish constitution. Means it is having fundamental rights, fundamental duties and as well as directive principles of the state policy, and we are following the bicameral system of the legislature. It is one of the reason for bulking of the Indian Constitution. In a federal state, residual powers of the legislature remains with the central government, similar to the Canadian Constitution. But in USA and Australia, residual power is the domain of the state government. Power to make a law on the areas which is divided into 3 lists, list 1, list 2 and list 3. The subject matter which are enumerated in the list 1, the union government has a power to make laws. The subject matter which are enumerated in the list 2, state government has a power to make the laws. List 3 is called a concurrent list. Regarding this list, the subject matter which are enumerated in the list 3, both the government, that is central government as well as the state government, has a power to make laws. If any controversy arises with regard to the concurrent list, suppose the central government made law and as well as the state government also made law. If any contradictory arises, in that circumstances, central government law will be prevail over the state. So we want to know what is residual power. The power divided into three lists, list 1, list 2, list 3. Remaining some of the powers, remaining some of the areas are not entered in any of the lists, they are called a residuary power. Regarding residuary power, central government has a power to make the laws. The Government of India Act 1935 was in operation when India got an independence. The Act 1935 Act was a voluminous document, and its incorporation has naturally made the Indian Constitution bulky. Next reason is India is a country of a great diversity. It's a country of several minorities, religions, languages, caste, race, etc. It consists of a provision for the protection of minorities' religion, languages and official languages, government services, electoral machinery, etc. In fact, in other countries, these matters are usually left to be regulated by the ordinary law of the land. In India, we are having only the single citizenship, the constitution having a detailed provision regarding citizenship. Next, the salient features of Indian constitution is the preamble. Preamble to the statute means it is an introduction to the statute. Preamble to the constitution means it represents the entire constitution in a written words. It is reflect the basic structure and spirit of the constitution. The preamble to the constitution embodies the fundamental values and philosophy on which the constitution is based. It describes the source nature, ideology, goals and objectives of the constitution. It describes the India as a socialist, secular, sovereign and democratic republic. As we all know that what is sovereign country? So we are the sovereign country. We are not under any administration, any foreign administration. We are the sovereign country. Socialist country means it is one of the objective of the Indian constitution to have a socialistic kind of a democracy, means egalitarian kind of a society. Secular means what we called Jatyatitati. Democracy means what we called Prajaprabhutva, that is republic means through general election we are elected the Prime Minister of India, that is a republic, that is the aim of the Indian constitution. That is objective of Indian constitution is social justice, economic justice, political justice as well as fraternity. Fraternity means bhavaikiti. It emphasizes the dignity of the individual and integrity, unity and integrity of the nation. Ekate matu samagrate. It declares the Indian people are sovereign. Word socialist and secular was inserted in the preamble by the 42nd Amendment in 1976. The same amendment also contributed to the changes of the words unity of the nation into unity and integrity of the nation. The significance of the preamble of the Indian Constitution lies with the words we the people. These words emphasizes the ultimate powers are vested in the hands of the people of India. Ultimately, people are supreme. The main objective of Indian Constitution is equality, justice, fraternity and liberty. Equality means samanati, justice means nyaya, fraternity means bhavaikite, liberty means swatantra. Equality. This implies equal opportunity for one and all. Justice is ensure the fair judgment in the field of politics, society and economy. Fraternity. It maintaining the integrity and strength of the country. Liberty of thought, liberty of expression. These are all the main objective of the preamble. Re-Beriberi case, question arises whether the preamble is a part of Indian Constitution or not. But Supreme Court finally held that preamble was not the part of Indian Constitution. But in Keshwananda Bharati case, court held that preamble is a part of Indian Constitution and Constitution, therefore Constitution must be read as a whole in the light of the preamble. Means when you read the Constitution, you should read along with the preamble. In S.R. Bommai case, again in Indira Gandhi versus Raj Narayan case, and again in Indra Swani case, and finally in I.R. Coelho versus State of Tamil Nadu case, court held that preamble is a part of Indian Constitution. If any attempt made to amend the original and preamble, it is a violation of a basic structure of Indian Constitution, because preamble is also one of the basic structure of the Indian Constitution. What do you mean basic structure of the Indian Constitution? We will study in the next unit. Fundamental rights is also one of the salient feature of Indian Constitution. There is no democratic constitution worthy of its name without fundamental rights. Fundamental rights are basic rights which are conformed to the citizens of nation by the Constitution. Generally, fundamental rights set out the rights of individual and responsibilities of the government. As we know that there is no right without responsibility. If you want to confirm the rights to the people, on the one hand, there must be a responsibility, there must be duty on the government. Otherwise, there is no meaning in the rights. That's why when the fundamental rights are conformed to the individual, there is a duty conformed on the government. These fundamental rights are dealt under the Article 12 to 35 under Part 3 of Indian Constitution. This is guaranteed right. We are called guaranteed right. Means these fundamental rights are a qualified right. It is not absolute right. Means they are subjected to reasonable restriction. Only through reasonable restrictions only these fundamental rights can be taken over by the government. Fundamental rights are guaranteed rights, means it is against the state. It is a guaranteed right against the state. Means state cannot intervene the fundamental rights of citizens of India unless through the procedure. These fundamental rights are divided into 5 categories, that is right to equality, Article 14 to 18, right to freedom, Article 19 to 22, right against exploitation, Article 23 and 24, right to freedom of religion, Article 25 to 28, and right to education, Article 29 and 30. These are all fundamental rights guaranteed to the individuals. Next one is directive principles of the state policy. It is also one of the salient features of Indian Constitution. It is enumerated in the Part 4th of Indian Constitution, that is in between Article 36 to 51. Unlike fundamental rights, directive principles of the state policies are not enforceable. But these fundamental rights are very important or very fundamental to the governance of the country, and they are the guidelines and supposed to be considered while making a legislation. Why this is fundamental to the governance of the country, why we are saying like that, means when we making the laws, now ಕಾನೂನನ್ನು ಮಾಡಬೇಕಾದ್ರೆ we are giving a more weightage to the directive principles of the state policy, because we are in the era of a welfare state, we are achieving the welfare state, we are giving a more importance to the directive principles of the state policy. Directly we cannot enforce the directive principles of the state policy, because it is a kind of a direction given by the constitution to the state. Constitution in the state ಗೆ ಕೊಟ್ಟಂತಹ ಒಂದು ನಿರ್ದೇಶನ, ಇದನ್ನು ನಾವು ಡೈರೆಕ್ಟ್ ಆಗಿ ಎನ್ಫೋರ್ಸ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ ಕೋರ್ಟಲ್ಲಿ ಪ್ರಶ್ನೆ ಮಾಡಲಿಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ. ಬಟ್ once the concept which is recognized under the directive principles of the constitution, it is converted into any enactment, legislation, then it is enforceable. Directive principles of the state policy lay down certain social, economic, political objective to achieve the true spirit of democracy. Over a period of time, directive principles, many of the directive principles of the state policy attained the status of fundamental rights either by the judicial interpretation or by amendment to the constitution. For example, right to education. Under Article 45 of Indian Constitution, right to education is the directive principles of the state policy. That is, state shall endeavour to provide free and compulsory education to all the children from the commencement of the constitution within the period of 10 years. But now it is fundamental right, it is inserted in 2002, that is Article 21A. It is a fundamental right of every citizen to have a free and compulsory education in between the age of 6 to 14 years. Parliamentary form of government, it is also one of the salient features of Indian Constitution. Constitution of India provides for parliamentary form of government both at center and as well as state government. It is also known as cabinet government, and sometimes it is called a parliamentary form of democracy. Executive is created out of parliament, therefore executive is accountable to the parliament. In a parliamentary form of government, there is a two type of an executive. One is the real executive, another one is the nominal executive. President is the nominal executive. All the powers formally vested with him, exercised in accordance with the aid and advice of the ministers of Council of Ministers headed by the Prime Minister. Prime Minister is the real executive and he exercises all the power of the executive power of the Union. There is a fusion between the legislature and executive because executive is created out of the parliament. That's why we see this kind of a fusion in parliamentary form of a government, and parliament exercises continuous control over the working of the Council of Ministers. Leader of the majority party of the parliament, that is Lok Sabha, is always appointed as a prime minister, and all ministers are essentially the members of the parliament. Ministers both act as a legislature as well as the head of the government assigned to them. Federation with a strong centralized tendency. We are having a federal state, no doubt in that. That is a union government as well as a state government. It is one of the characteristic features of the federal system, that is a power distributed between the federal government as well as the state government. In a federal system of the government, state is not subordinate to the central government, or it is not direction under the central government. Federal system of a government means state government and central government are coordinate with each other. But one of the characteristic features of an Indian federal system which make the centralized strong tendency means central government is more stronger than the state government. Means under Article 3 of Indian Constitution, Parliament by way of making any legislations unilaterally create any new state. It can alter, modify the territory of any state, and it can change the name of any state. In addition to that, there are some of the provisions in the Indian Constitution which empower the Parliament to legislate even in the subject matter which are enumerated in the state list. Under Article 250, 352, 353 of the Indian Constitution, the power is only exercised by the President, which requires the approval of both the houses of the Parliament. Under Article 250, if an emergency proclamation of an emergency is there, in that circumstances, Parliament have a power to make the laws with regard to the subject matter which are enumerated in the state list. Under Article 352, the President has a power to declare the national emergency to the whole India or any part of the India. Under Article 353, President has a power to issue any ordinance with regard to any state. Within 1 month, these ordinances must be approved by both the houses of the Parliament. What it shows, the provisions which are we are find in the Indian Constitution make the Indian Constitution unitary as well as federal according to the requirement and circumstances of the circumstances. In a normal time, our government working as a federal system. In a war time, our government is working as a unitary system. Dr. Ksou has described the Indian Constitution, means he has described that federal state with the unitary spirit. A unique blend of rigidity and flexibility is one of the basic features of Indian Constitution. Constitutions are sometimes classified into flexible and rigid. A flexible constitution is one in which amendment can be made rather easily as enacting the ordinary law. Amendment ಅಂದ್ರೆ ಕಾನೂನನ್ನು ತಿದ್ದುಪಡಿ ಮಾಡತಕ್ಕಂಥದ್ದು. ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅನ್ನು ತಿದ್ದುಪಡಿ ಮಾಡಬೇಕಾದ್ರೆ ಬಹಳ ಈಸಿಯಾಗಿ ಮಾಡತಕ್ಕಂಥದ್ದು. ಲೈಕ್ ಆರ್ಡಿನರಿ ಲಾ ಅನ್ನು ಹೇಗೆ ಮಾಡ್ತೀವಿ ಹಾಗೆ ಮಾಡಿದ್ರೆ ದಟ್ ಈಸ್ ಫ್ಲೆಕ್ಸಿಬಲ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅಂತ ಹೇಳಿ ನಾವು ಕರಿತೀವಿ. ಅಥವಾ ಆರ್ಡಿನರಿ ಲಾ ಹೇಗೆ ಒಂದು ಕಾನೂನನ್ನು ನಾವು ಪಾಸ್ ಮಾಡ್ತೀವಿ ಹಾಗೆ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅಮೆಂಡ್ಮೆಂಟನ್ನು ನಾವು ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. ಸಮ್ ಮೋರ್ ಟೆಕ್ನಿಕಲ್ ಪ್ರೊಸೀಜರ್ನ ನಾವು ಅಡಾಪ್ಟ್ ಮಾಡ್ಕೊಳ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರೆ ದಟ್ ಈಸ್ ಕಾಲ್ಡ್ ಎ ರಿಜಿಡ್ ಪ್ರೊಸೀಜರ್ ಅಂತ ಹೇಳಿ ನಾವು ಕರಿತೀವಿ. ದಟ್ ಈಸ್ ಎ ರಿಜಿಡ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅಂತ ಹೇಳ್ತೀವಿ. ಬಟ್ ಇಂಡಿಯನ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಇಸ್ ಬೋತ್ ದ ಮಿಕ್ಸ್ಚರ್ ಆಫ್ rigid and flexible procedure it has. That's why we are called it is a flexible as well as a rigid. Some provisions of the Indian Constitution can be amended by the simple procedure as followed by enacting ordinary laws.
एक सूचना देना चाहता हूं, श्री प्रिंस राज जिन्हें अभी तक विभाजन संख्या आवंटित नहीं हुई है, उनको सीट पर पक्ष विपक्ष में मुद्रित पर्ची अपना मतदान रिकॉर्ड कराने के लिए दी जाएगी. वे पर्ची पर विनिष्ट स्थान पर अपना नाम, पहचान पत्र संख्या, निर्वाचन क्षेत्र, राज्य और दिनांक को स्पष्ट लिखकर और पर्ची पर हस्ताक्षर करके अपनी इच्छानुसार मतदान करें। यदि मान्य सदस्य मतदान में भाग नहीं लेना रिकॉर्ड करना चाहते हैं तो मतदान में भाग नहीं लेना वाली पर्ची की मांग कर सकते हैं। प्रदान की जाए। जो सदस्य इसके पक्ष में हाँ कहें, जो सदस्य विरोध में ना कहें। अब मतदान।
अब मैं प्रोसेस स्टार्ट करूंगी। आप गॉन्ग की ध्वनि सुनने के पश्चात ही बटन दबाएं।
While the rest of the constitution is amended by the special, more difficult and technical procedure which requires special majority, means 2/3 of the members who are sitting and voting in the house, and sometimes it also requires including special majority half of the state ratification. That's why it is called a rigid procedure. Judicial review is also one of the salient features of Indian constitution. It is also basic structure of Indian constitution. So we will come to know that in coming units, basic structure of Indian constitution. So judiciary play an important role as a protector of constitution values. Judicial review is a great weapon in the hands of court, which implies a limited government. The fundamental object of judicial review is to determine the unconstitutionality of the legislative acts. Constitution of India has expressly established the doctrine of judicial review in several articles such as Article 13, 32, 131 to 136, 143, 226 and 227 of Indian Constitution. Article 13, what it says, what it deals, we know that. Any law, according to the Article 13 of Indian Constitution, any law made by the Parliament which is contrary to the third of Indian Constitution, to the extent of it contradictory, it should be declared as a null and void or unconstitutional. Article 32, it is a writ jurisdiction which is conformed to the Supreme Court by the Constitution. Article 131 to 136, it is a virginal jurisdiction conformed to the Supreme Court by the Constitution. Article 143, it is an advisory jurisdiction of the Supreme Court, means President may seek the opinion of the Supreme Court regarding any of the issues like facts or law which are the public importance. Article 226 and 227. Article 226 is the writ jurisdiction which is conformed to the High Court, and 227 High Court has a superintendent's power over all the lower courts. These are all expressly and explicitly shows the judicial review. One important point I want to note it here, that is observation made by the Dr. Ambedkar regarding judicial review. What he says, if I was asked to name any particular article in the Constitution as the most important, it is the Article 32, without which Constitution would be nullity. It would not refer any other article except this one. It is the very soul of the Constitution and very heart of it, and I am glad that the House had realized its important. Means Article 32 ಎಷ್ಟು ಇಂಪಾರ್ಟೆಂಟ್ ಅನ್ನೋದನ್ನ ಡಾಕ್ಟರ್ ಅಂಬೇಡ್ಕರ್ ಹೌಸಲ್ಲೇ ಅದನ್ನು ಘಂಟಾಘೋಷವಾಗಿ ಅದನ್ನು ಅವರು ಹೇಳಿದ್ದಾರೆ. ವಿತೌಟ್ ಆರ್ಟಿಕಲ್ 32 ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ಗೆ ಇರಿಸು ಮೀನಿಂಗ್ ಇನ್ ಹರ್ಟ್. ಏನಕ್ಕೆ ಹಾಗೆ ಹೇಳಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ, ಸೊ ದ ನಂಬರ್ ಆಫ್ ರೈಟ್ಸ್ ಆರ್ ಗ್ಯಾರಂಟಿ ಟು ದ ಇಂಡಿವಿಜುವಲ್ಸ್. ಈ ರೈಟ್ಸನ್ನು ನಾವು ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ರೆ ಓನ್ಲಿ ಥ್ರೂ ಆರ್ಟಿಕಲ್ 32 ವಿ ಕ್ಯಾನ್ ಅಪ್ರೋಚ್ ದ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಫಾರ್ ದ ಪ್ರೊಟೆಕ್ಷನ್ ಆಫ್ ಅವರ್ ಫಂಡಮೆಂಟಲ್ ರೈಟ್ಸ್. Right to move the Supreme Court under Article 32 itself is our fundamental right. That's why Dr. Ambedkar made an observation like this. Universal adult suffrage, it is one of the salient features of Indian Constitution. The right of the people to vote and elect their representative is called a franchise. India has adopted adult suffrage. Every citizen attained the age of 18 or more has a right to vote without any discrimination. Article 326 as amended by the Constitution in 1998 lowered the voting age from 21 to 18 years. We know that those who are completed the 18 years having a voting right. Through this right, all citizens shall take part in the process of formation of the government. So it is a single citizenship. It is also one of the salient features of Indian constitution. So as we know that we are having a federal state, that is central government at the center and state government in each provinces. So we are having a federal state. In a federal state, normally there is a double citizenship. In USA, every citizen, besides being a citizen of United States of America, is the citizen of the state in which he or she resides. But in India, we are having a two-level government at the center and a state, but only the one single citizenship. There is no separate state citizenship. Every Indian is the citizen of India. Independent of judiciary means every judge is totally free to adjudicate the matters before him in accordance with his perception of the facts and comprehension of the law, without any influence, inducement, pressure or favor directly or indirectly from any angle. In order to ensure the independence and impartiality of the judiciary, the constitution makes a provision for the appointment of the judges. So if you read the article 124 to 143, we will get to know the independence of the judiciary. Chief Justice of India appointed by the President and aid and advice of the Council of Ministers headed by the Prime Minister.
I, Deepak Mishra, having been appointed Chief Justice of the Supreme Court of India, do swear in the name of God that I will bear true faith and allegiance to the Constitution of India as by law established.
That I will bear true faith and allegiance to the Constitution of India.
Other judges of the Supreme Court are appointed by the President in consultation with the Chief Justice of India. Chief Justice of all the High Courts are appointed by the President in consultation with the Chief Justice of India. Appointment of all the judges of the High Court appointed by the President of India in consultation with the Chief Justice of High Court and Governor of the respective state. What it shows, ಇದೇನು ಹೇಳ್ತಾ ಇದೆಯಪ್ಪ ಅಂತ ಹೇಳಿದ್ರೆ, here executive authority not involved in appointment of any judicial members. Only the Chief Justice of India na appoint ಮಾಡುವಾಗ ಮಾತ್ರ Council of Ministers headed by the Prime Minister aid and advice ಮಾಡ್ತಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ, there is an executive interference ಮಾತ್ರ ಇರುತ್ತೆ. ಆ ಲೆವೆಲಲ್ಲಿ ಬಿಟ್ಟು ಚೀಫ್ ಜಸ್ಟಿಸ್ ಆಫ್ ಇಂಡಿಯಾವನ್ನು ಬಿಟ್ಟು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜಸ್ ಇರ್ಬೋದು, ಚೀಫ್ ಜಸ್ಟಿಸ್ ಆಫ್ ಆಲ್ ದ ಹೈ ಕೋರ್ಟ್ಸ್ ಇರ್ಬೋದು, ಅಥವಾ ಜಡ್ಜಸ್ ಆಫ್ ದ ಹೈ ಕೋರ್ಟ್ ಇರ್ಬೋದು, ಅವರನ್ನು ಅಪಾಯಿಂಟ್ ಮಾಡ್ತಕ್ಕಂಥದ್ದು ದಟ್ ಈಸ್ ಪ್ರೆಸಿಡೆಂಟೇ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ರು ಕೂಡ ಓನ್ಲಿ ಇನ್ ಕನ್ಸಲ್ಟೇಷನ್ ವಿತ್ ದ ಚೀಫ್ ಜಸ್ಟಿಸ್ ಆಫ್ ದ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆ್ಯಂಡ್ ಚೀಫ್ ಜಸ್ಟಿಸ್ ಆಫ್ ದ ಹೈ ಕೋರ್ಟ್ ಅವರು ಮಾಡಲೇಬೇಕಾಗತ್ತೆ. ಬಿಕಾಸ್ ಇನ್ ಕನ್ಸಲ್ಟೇಷನ್ ಮೀನ್ಸ್ ದೇ ಹ್ಯಾವ್ ಟು ಗಿವ್ ಎ ವೇಟೇಜ್ ಟು ದ what the opinion expressed by the Chief Justice of India and as well as the Chief Justice of the High Court as the case may be. In order to ensure the independence and impartiality of the judiciary, Constitution makes the provision for the following matters: appointment of judges by the President after consultation with the judicial authorities. Security of the tenure is guaranteed to every judge. Salary of the judges are paid out of consolidated fund of India. And finally, no discussion can be made with respect to the conduct of judge in a legislature. No discussion can be made with respect to the conduct of a judge in a legislature. Means, ಯಾವುದೇ ಜುಡಿಷಿಯಲ್ ಡಿಸಿಷನ್ ಅನ್ನು ಕೊಟ್ಟಾಗ ಆ ಡಿಸಿಷನ್ ಬಗ್ಗೆ ಇರ್ಬೋದು ಅಥವಾ ಆ ಜಡ್ಜಿನ ಕಾಂಡಕ್ಟ್ ಬಗ್ಗೆ ಇರ್ಬೋದು, ಯಾವುದೇ ರೀತಿಯಾದಂಥ ಡಿಸ್ಕಷನ್ ಕ್ಯಾನ್ ಬಿ ಮೇಡ್ ಇನ್ ದ ಬೋತ್ ದ ಹೌಸಸ್ ಆಫ್ ದ ಪಾರ್ಲಿಮೆಂಟ್. All are what it shows the independence of the judiciary. It ensures the efficiency, independent. Why we are maintained reason is to ensure the efficiency of the judiciary must work transparently without under any pressure and favor. Last one is secularism. We know that India is a secular state. Means ಜಾತ್ಯತೀತತೆ ಅಂತ ಏನು ಕರಿತೀವಿ ನಾವು, that is called a secularism, secular state. A secular state is neither religious nor irreligious or anti-religious. Rather, it is neutral in the matters of religion. India is a country of several religions, and each individual has a fundamental right to practice, profess, and propagate any religion he likes. In India, there is no state religion, means it does not have any official state religion. State-owned educational institutions cannot impart religious instruction. Means government education institutions or any institution, if it having any aid from the government, cannot give any religious instruction. The word secular was not present originally in the preamble. It was added by the 42nd Amendment in 1970s. Following are some of the features of Indian secularism. State should not have any religion of its own. All the religions shall be equally protected by the state. Free exercise of the right to freedom of religion. State shall not discriminate against any particular religion. It means state shall not prefer, favor, disfavor any particular religion. Thank you for patience hearing. Thank you one and all.